Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, this video is going to be some information for our brothers and sisters in Illinois, but I think many of you elsewhere probably need to pay attention to this too, because I think we have a playbook for what we're going to see as far as what the gun grabbers are going to be advancing under their historical analogs and how to play that for future gun control legislation. As you know, we have quite the Donnybrook brewing out there in Illinois right now. It all goes back to the passage of their assault weapon ban, which 72 hours prior to its passage was nothing more than an innocuous piece of insurance legislation, and that has led to lawsuit after lawsuit after lawsuit being dropped. The most recent of one, unfortunately, turned out to be an unsuccessful attempt at a temporary injunction. We need to take a look at what the judge did, how the judge did it, why the judge did it, and what the judge said, and figure all this out so that we can educate ourselves. So today, let's spend a few minutes and talk about when judges help disarm their citizens. Okay, so the case we're talking about today is out of Illinois. It's a case called Bevis versus City of Naperville. Now, I understand that Mr. Bevis has challenged other gun ordinances in the state of Illinois and is quite notorious for this, but kudos to him. The City of Naperville had passed its own assault weapon ban, just as terrible as the one that was passed by the state of Illinois as a whole, and had sued the City of Naperville for a temporary injunction, asking that this law not be implemented. Now, as we know, many of the other lawsuits that have asked for injunctions against the state of Illinois for their imposition or enforcement of the assault weapon bans have in fact been granted as it relates to the named plaintiffs. It does not mean that every citizen of Illinois is enjoying freedom as though they were Americans, because that is not what they are experiencing. But for many of the named plaintiffs in some of those lawsuits, the rules do not, or the current new laws do not apply to them. Now, this case was argued before the Honorable Judge Virginia M. Kendall in the U.S. District Court for the Northern District of Illinois. And as I mentioned, the plaintiffs in this case, Mr. Bevis, had asked for a temporary injunction to preclude the state of Illinois from enforcing that law against them. That motion was denied, and I want to talk about what's going on here, because for those of you who've geeked out on this channel for a long time, and if you watched any of the other channels that do a good job of trying to educate you, you will know that post-Bruin, we are in a world now where if the text of the Second Amendment covers the activity that's being regulated, it is presumed to be protected by the Second Amendment. And unless the government can come up with a historical analog that demonstrates that we as a country have typically allowed for those types of firearm restrictions, absent that, the restriction or regulation is per se unconstitutional. Now, when we go back and we try to look at a historical context, and this was not homework that we did. You see, Justice Scalia did this way back in District of Columbia v. Heller. What we have come to find out is that we have a rich tradition of allowing government to regulate firearms which are both dangerous and unusual. This is known as the common use test, developed by Justice Scalia in the Heller case, geeked out by all of us in this video right here, and is still good law. So essentially, firearms which are dangerous and unusual, there is historical acceptance of regulating them, but firearms which are neither dangerous nor unusual or do not have that combination are for regulations that we do not constitutionally permit. So, with that in mind, what was the ruling of the court? The ruling of the court was as follows as it relates to this temporary injunction. As set forth below, although the plaintiffs have standing to bring this lawsuit, they are unlikely to succeed on the merits of their claim because Naperville's ordinance and the Protect Illinois Communities Act are consistent with the Second Amendment's text, history, and tradition. And I know that comes as news to many of you, as it did to me, so I figured, hey, I've got to read this opinion a little bit more. What does Judge Kendall know that none of us else do? And, well, I've learned a lot of things about that. Because I think, with all due respect to Judge Kendall believes that the test is dangerous or unusual. and therefore any weapon which is inherently dangerous, she believes government has the right to regulate. Now, let us not forget that all weapons would be dangerous, because that is exactly what they're designed to be, is dangerous, okay? However, the test really is one of dangerous and unusual. But this is how the court viewed the Second Amendment. The court recognized, however, that the right secured by the Second Amendment is not unlimited. The court gave two limiting examples. One, as United States v. Miller explained, those weapons not typically possessed by law-abiding citizens for lawful purposes are unprotected. And two, measures related to long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms are presumptively lawful. And even assuming that in arguendo, weapons not typically possessed by individuals, well, that gets us to that unusual part of the dangerous and unusual part of the common use test. But here's the thing. We know that semi-automatic rifles in the AR platform are, in fact, the most commonly used rifle for multiple purposes, sporting and self-defense, just to mention a couple. And assuming our arguendo that point two is correct, that there is a rich tradition of restricting where firearms can be possessed or what types of people can possess firearms, while that may be true, there is nothing here that mentions an absolute ban on an entire platform of firearms. And for those of us who've been geeking out on this for a while, we know that we have gone from this two-part balancing test where judges could essentially put their thumb on the scale and weigh societal needs as they see fit to justify the constitutionality of restrictive gun control measures. That two-part analysis has been replaced for good by a one-part test. Justice Kendall, unfortunately, really misses that old two-part test, and even so much as says so. In practice, step two did the heavy lifting. Courts regularly assumed without deciding the Second Amendment covered the regulated conduct and proceeded to analyze the regulations under the chosen means and scrutiny, most often intermediate scrutiny. And so think about it. What the judge is saying is hey, listen, I really like the two-part test because under the old two-part test, yeah, sure, it was covered by the Second Amendment, but so what? I had this second part that I could use to strike the balances that I want to achieve the desired results. Now, one of the things that Justice Kendall is really caught up on is she's trying to take language from Justice Kavanaugh and Chief Justice Roberts in some of their concurring opinions. And I think what she's doing is she's trying to build a mountain out of a molehill. This is how she refers to it. Even accepting that standard, as Justice Kavanaugh emphasized in his concurrence, joined by Chief Justice Roberts, the Second Amendment still permits a variety of gun regulations, such as the examples already announced in Heller. And yet nowhere in those examples announced by Heller does it authorize, does it condone, does it okay the complete ban of an entire platform of firearm. Now, recognizing that the state has to come up with some type of historical analog to even have a snowball's chance in hell of justifying the constitutionality of this regulation, this is how the judge put it. Accordingly, this court must consider the challenged assault weapon regulation on a tabula rasa. The government must justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. The analog need not be a historical twin or a dead ringer for historical precursors, so long as it is sufficiently analogous to pass constitutional muster. And by the way, for those of you who like to geek out on Latin, tabula rasa means to wipe the slate clean and to start all over. Now, the court did really wipe the slate clean and start all over, but what they did is they wiped the slate clean on the common use test. Because what Justice Kendall then does is go through a long and very distinct historical analysis and diatribe about all the other types of weapons that have been prohibited, such as sand clubs, billy clubs, daggers, dirks, swords, bowie knives, and things such as that. And after going through all of that tradition of banning other types of firearms, all of which, by the way, may be deemed both dangerous and unusual, well, the judge comes to the following conclusions. The history of firearm regulation, then, establishes that governments enjoy the ability to regulate highly dangerous arms and related dangerous accessories. The final question is whether assault weapons and large capacity magazines fall under this category. They do. That's right. The judge's findings is that government enjoys the ability to restrict your Second Amendment rights. And what she has done so is she's developed a new one-part common use test, which is if a weapon is dangerous, then it can be banned. And ultimately, the court makes the final ruling as, under this framework, Naperville's ordinance and the Protect Illinois Communities Act are constitutionally sound. The text of the Second Amendment is limited to only certain arms, and history and tradition demonstrate that particularly dangerous weapons are unprotected. And so with that, Mr. Bevis and the petition for the temporary injunction was effectively denied. Now, with all due respect to Judge Kendall, and I have to be very careful as a licensed member of the Bar Association about what I say here. However, there is a common use test. It is well articulated in District of Columbia v. Heller. It is spoken of again in Bruin, and there are a litany of other cases that talk about the common use test. The common use test is a very straightforward test. There is a historical tradition in this country for allowing government to regulate firearms which are both dangerous and unusual. Not dangerous or unusual, dangerous and unusual. And with all due respect, Your Honor, what you have done is you have now developed a one-part common use test, which is if a firearm or any weapon is dangerous, it may be regulated. And under that reasoning, every single weapon known to man could be regulated by the state of Illinois. Obviously, we will keep you all apprised on this and all the other things that are going on in Illinois because it is turning into a big old-fashioned fist fight out there in the land of Lincoln. Listen, in the meantime, if you guys have any other questions about what's going on in Illinois or anything else related to what's left of our Second Amendment rights, you guys should know the drill by now. You can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, in the meantime, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.